Okay, I think we are ready to go. Hi, welcome everyone. My name is Alexis Stoymanoff, and I'm the Communications Director here at West Coast Environmental Law. Thank you so much for joining us today for our webinar on coastal and ocean protection law in BC. I am zooming in today from the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh Nations, also known as Vancouver. And West Coast headquarters is here located on these territories, and we're very grateful to be able to live and work on these lands in this place right next to this big, beautiful coast. And today, my brilliant colleagues are going to tell you about some of the laws that we can use to protect that beautiful coast. We'll be hearing from 4 of our staff lawyers, Stephanie Hewson, Georgia Lloyd-Smith, Michael Bissonnette, and Deborah Carlson. And we are also very excited to have a special guest joining us, our former West Coast colleague, Linda Nowlin, who led our marine law team up until earlier this year and who's played a huge role in the work that we're going to be discussing today. So along with this webinar, we're really excited to be releasing today our guide to coastal and ocean protection law in British Columbia. It's an incredible resource for anyone looking for information on the complex web of laws that apply to the coast. And since we've only got an hour with you, this session is just going to provide a brief introduction, but I'd really encourage you to check out the guide online, the links there in the chat to learn more and find the information that's most relevant to you. We've had a surprisingly large number of questions submitted during registration, some of which will be covered by our lawyers in the presentation, and some of which we'll be addressing during the Q&A at the end. Since we do have a limited time for questions, we've kind of collected some of the more common questions, and we'll be posting those in the Q&A function, where you can like or upvote the questions that you're most interested in to help us prioritize. So you're welcome to participate during the webinar using the chat. I see some people are already in there, as well as the Q&A function that I mentioned, and both of those should be available in the icons at the bottom of your Zoom window. And if you'd like to test out the chat, feel free to send us a message letting us know where you're zooming in from today. So I think that's it for the housekeeping for now. And I think everyone's really excited to dive into this exciting topic. And with that, I will turn it over to Linda Nowlin to say a few words.
Thanks, Alexis, and great to be here. I'm so happy to be invited here today for this long-awaited launch of this guide. I'd like to start with a quote from oceanographer Sylvia Earle. "Even if you never have the chance to see or touch the ocean touches you. With every breath you take, every drop of water you drink, every bite you consume." The ocean inspires us and nurtures us in so many ways, not only providing food and jobs, but also recreation, beauty, serenity, and solace, which we need especially now in these troubled pandemic times. It's no wonder our ocean laws also use inspiring language, and here are a few examples. Internationally, the Law of the Sea Treaty, the Constitution for the World's Ocean, has a lofty goal to contribute to a just and equitable international economic order. And it has a clear and simple requirement. States have the obligation to protect and preserve the marine environment. No qualifications. The World Heritage Convention, one of the world's most popular treaties with 194 countries signing on, aims to do nothing less than protect sites all over the world with outstanding universal value. There's a proposal right now to create a World Heritage Site nearby in Howe Sound in our backyard. Federally, the Oceans Act also inspires. It affirms that the ocean is the common heritage of all of us, says that Canada has a role as a world leader in oceans, and stresses that conservation is of fundamental importance. And for the first time, thanks in part to West Coast's efforts, the Act now defines ecological integrity and sets it as a reason for creating a marine protected area. Indigenous ocean laws are also inspiring. The name alone of the proposed Healthic Oceans Act is a window of insight into a different way of being in relationship with the ocean. It's called Respecting and Taking Care of Our Ocean Relatives. The Tsleil-Waututh Nation Burrard Inlet Action Plan inspires with its statement, of stewardship responsibility that includes restoration, restoring conditions that provide the environmental, cultural, spiritual, and economic foundation for our communities to thrive. Provincially, the Islands Trust Act sets up an inspiring legal trust obligation to preserve and protect the Gulf Islands and their unique amenities and environment for the benefit of the residents and for British Columbia generally. And there are many other inspiring coastal protection policies from local governments up and down BC's extensive coast, including the City of Vancouver, who most recently inspired us to think big with 6 bold moves to address the climate emergency, including a bold move on shoreline restoration. There are many, many, many more coastal and ocean protection laws. All governments share responsibility for regulation of our blue planet. It's a tangled web indeed, and that's why we wrote this guide. 3 years ago, NGOs and Indigenous nations came together at a workshop hosted by Coastal First Nations on marine planning and protection. West Coast was asked to provide an overview of ocean laws for the workshop. Innocently, we agreed and started compiling charts of marine and coastal laws, soon realizing that not only was there no overall text we could look at, there were few ocean law resources available for any single order of government. How could this be when the ocean is so vital and so many of today's environmental issues center on the ocean, whether it's oil tanker expansion projects that carry the risk of catastrophic spills, a crisis in the health of wild salmon, cumulative threats to Canada's most endangered marine mammal, the southern resident killer whale, a warming ocean from climate change causing sea level rise with devastating consequences for ecosystems and communities, or the rising tide of plastic pollution that chokes the seas and leads to the dire prediction that if we don't change our ways, there will eventually be more plastic than fish in the sea. So we set out to write this guide 3 years ago. The initial set of charts we produced for the Coastal First Nations workshop became the germ of the guide. We wanted to create an accessible resource for everyone concerned with ocean and coastal protection. The guide focuses on one particular area of coastal and ocean law, legal tools that protect these spaces, often known as marine spatial protection. Writing on that topic by itself was a big challenge, as we were determined to cover all applicable laws: Indigenous, international, federal, provincial, municipal, and interjurisdictional. And today, here it is at last, the Guide to Coastal and Ocean Protection Law in BC. I'm so pleased to have been part of this project with the wonderful team you're about to meet. We're extremely proud of the result. And we would all like to give special thanks to the funders and collaborators who've supported the work over the past 3 years. A big, giant, heartfelt thank you to the Sitka Foundation and the Gordon and Betty Moore Foundation. We couldn't have done it without you. And thanks to all the West Coast authors that Alexis listed at the beginning and you'll hear from today, led by Stephanie Hewson, who really got this project over the finish line and corralled us all to produce the result that you now see. Georgia Lloyd-Smith, Deborah Carlson, and Michael Bissonnette, as well as the many law students, advisors, reviewers, allies, and fellow ocean protectors and advocates who helped complete the guide. By putting the law in all of your hands, we're hopeful that another message from Sylvia Earle will come true. Protect the natural systems as if your life depends on it, because it does. Our lives do depend on making peace with nature. Over to you for this inspiring presentation.
Thanks, Linda. Such wonderful opening remarks. So my name is Georgia Lloyd-Smith, and first, I just want to acknowledge and appreciate all of you for joining today, and also for the thoughtful questions that you provided when you registered. We had a wide range of questions submitted that really showed the care that you all feel for the ocean, that we all feel. So some of the questions were about the range of threats that the ocean is facing, from oil spills to aquaculture, shipping, oil tankers, plastic, sea level rise, concerns about the health of wild salmon and other species at risk. And when we sat down to think about how we were going to prepare a presentation to talk about the comprehensive range of laws addressing coastal and ocean protection in an hour, which is quite a feat, given that our guide, I think, is about 300 pages, we decided that instead of focusing on each of these issues one by one, we would tackle the complex and very exciting topic of jurisdiction, because the question of jurisdiction really underlies all of these threats, because jurisdiction is essentially the power that governments have to create laws about different areas, and also the responsibility that governments hold for caring for the ocean. And we figured that would be kind of a more efficient way of providing you information for the question of, like, who do I call when, you know, an abandoned vessel floats up, or who do I call within the governments to address an oil spill? And it's not easy. There's a lot of government agencies involved, and we're going to hope to shed some light on those big questions for you today. And just to acknowledge that before we start, it's really Indigenous nations who've been along the coast governing their territory since time immemorial that provide the foundation of our governance today. And so I will now pass it on to Stephanie to talk a bit about international jurisdiction.
Thanks, Georgia, and thank you, Linda and Alexis, for your opening. It was really wonderful to hear. Alexis, if you don't mind going ahead to the next slide, and the one after this. So I'll give you a brief outline of what we'll talk about today. Georgia's touched on it really, but we're going to focus on marine jurisdiction, and I'll start with an overview of what that looks like under international law. Georgia will talk about Indigenous law. Michael and I will talk about federal and provincial law, and Deborah will tell us about the important role that local governments play in protecting the ocean. So if you could go to the next slide, Alexis. International law really sets the framework for ocean governance and conservation. And we have a few really key conventions listed here. The United Nations Convention on the Law of the Sea, which is sometimes referred to as the Constitution of the Oceans, lays out the different jurisdictions that coastal states have on the ocean that's adjacent to them. The United Nations Declaration on the Rights of Indigenous Peoples and the Convention on Biological Diversity both set the framework for both governance and conservation. And international law also sets targets that Canada has committed to in terms of protecting the ocean, and different designations under international law can be used to bring attention to an area, to build capacity and increase political will to protect different parts of the ocean. I think it's really one important distinction to make, though, is that international law isn't enforceable in Canada unless it's incorporated into domestic law. So for the UN Convention on the Law of the Sea, for example, those maritime zones that I'll talk about in a minute are incorporated into Canadian law through the Oceans Act. So on this next slide, we have an infographic that shows you a bit of the different zones and jurisdiction that Canada has and all coastal states have over waters adjacent to their landmass. And the main takeaway from this is that a coastal state's jurisdiction is strongest closest to shore and decreases as you move away from shore. So a couple key markers in this chart are the internal waters, which are considered pretty much to be part of the country, where a state has full jurisdiction. The territorial sea, which is up to 12 nautical miles offshore, which are considered to be also within a country's jurisdiction. And then there's an area from 12 to 200 nautical miles offshore on the BC coast, which is called the Exclusive Economic Zone. And that area is an interesting place where Canada has sovereign rights, but not complete jurisdiction in the same way it does in the other areas. And then beyond the Exclusive Economic Zone is the high seas, which are outside the boundaries of any country. So we have a map here that might help contextualize this a bit more in our next slide. And it is a map of the BC coast. And it shows the different maritime zones, the red hatching being the exclusive economic zone, the blue band being the territorial sea, and then the internal waters being to the east of Vancouver Island and also potentially Haida Gwaii as well. And Michael's going to talk a little bit more about that because that's quite a unique part of BC coastal jurisdiction under international and Crown law that's distinct from other provinces in Canada. So I think, yeah, I'll pass it now to Georgia to talk a bit about Indigenous law.
Thanks, Stephanie. So as I mentioned at the beginning, it can't be said enough that prior to colonization, what is now known as Canada was governed by Indigenous nations using their own laws and governance systems. And that, of course, includes the entire coast of what is now known as BC. So there's no area up the coast or no area across Turtle Island or now Canada that is not Indigenous territory and is not subject to the laws of Indigenous peoples. And I could say that a million times, but I think it's just important to recognize that as the foundation of any effort to use laws, Canadian laws, to protect the coast and oceans. Next slide, please, Alexis. Thanks. Yeah, so Indigenous nations have inherent jurisdiction to govern their territories. And the word inherent means that it exists regardless of recognition from Canadian governments. And that said, the Canadian Constitution in Section 35 does recognize Aboriginal rights and title, and that is a source of Indigenous jurisdiction within Canadian law. And also, as Stephanie mentioned, the United Nations Declarations on the Rights of Indigenous Peoples, which is an international international kind of treaty that essentially sets out a comprehensive range of rights for Indigenous peoples that now British Columbia last year has enacted a law to implement UNDRIP in BC. And just today, the federal government tabled a bill to implement UNDRIP in federal laws. So exciting times. Next slide, please, Alexis. So I'm going to speak really briefly to an example, which might highlight some of the interesting questions that emerge as between Indigenous jurisdiction and, in this case, primarily federal jurisdiction. So this all takes place in Kitasoo-Heihei's territory, which is in the central coast of BC. The main village is Klemtu. And there's been an ongoing conflict around herring and the herring fishery. The photo here on the top right is a photo of the herring spawn, and that's all herring sperm that's in the water to make it all milky like that. And then the photo on the bottom left is a photo of Kitasoo-Heihei fisher peoples harvesting herring roe in the traditional style, which is essentially emerging cedar boughs and other branches into the water and harvesting the roe without harming the adult herring. And this is something that the Kitasoo-Heihei's people and others along the central coast and up and down the coast have been doing since time immemorial. Under their own laws, they have a complex array of laws that govern how these herring fisheries occur. And then the photo on the right shows what's allowed under Canadian law, which is commercial harvest of herring, whereby big nets scoop up the herring and the adults are killed one by one and then opened up and their roe are taken out. I could go into a lot more about this story, but essentially there's a conflict here because the Kitasoo-Heihei's people do not want commercial fisheries, which are in many cases allowed under Canadian law within certain parts of their territories so that they can continue to harvest herring roe under their own laws. And this has come into conflict where now the Kitasoo-Heihei's are interested in establishing an Indigenous protected area, so an area under their own law that prohibits the commercial herring fishery from taking place in an area called Kitasoo Bay. So this is one example of many initiatives that Indigenous nations are taking up and down the coast under their own laws and authority to govern the coastal and ocean area. If you could go forward to the next slide, Alexis. And it's an example of an emergent term, which is Indigenous protected and conserved areas, which are areas that are Indigenous led and are governed through Indigenous laws and governance. And it's a really exciting emergent area that we've done a bunch of work on with nations. And I guess I encourage you to read the guide for more information on that. And yeah, it's a complex area of law, but I'm happy to take any questions at the end. And I'll end it there and pass it over to Michael. Thanks.
Thank you, Georgia. I am going to talk next about the different powers that the federal government and the provincial government have to manage and protect ocean spaces. And just one important disclaimer for this section. First of all, this is quite a complex area of law, so I'm going to be giving a high-level overview of this. But I know that you all have very specific questions about different powers. So hopefully this will give you an idea, and hopefully we can answer some of those specific questions at the end in the Q&A. The other very important disclaimer I want to give is that I'm going to be talking about the powers of the federal government and the provincial government. So I'll say things like the federal government has the power to regulate fisheries, or I will say something like this order of government has or holds the crown title in an area. And I just want to be clear, it doesn't matter whether it's the federal or the provincial government. Their powers with respect to the ocean and anywhere else in Canada are subject to rights and title of Indigenous nations. So when I talk about a power like the fisheries power, that's subject to Aboriginal rights and title. And those rights, as Georgia pointed out, are recognized in our Constitution. And there's very important constitutional responsibilities to respect those rights that have to be met. And so that's not a negotiable thing. The federal and provincial governments have to meet those rights under the Constitution. Okay, so moving on, I think when most people think about ocean management, the level of government that they generally think about is the federal government. And they do so with good reasons. And I'll give you two of those good reasons. The first reason is that under the Constitution, a number of activities and areas were divided between the provincial government and the federal government. And two very important ocean activities were given the responsibility to the federal government, and those are fisheries and shipping. So what that means is the provincial government cannot directly regulate those two activities. Only the federal government can. And given those two activities are some of the most important activities in the ocean, those are quite significant powers that the federal government has that the provincial government does not. The other reason that the federal government has quite substantial powers to make laws in ocean areas is that most of the seabed of the areas that are considered within, of the waters that are considered within the state of Canada, most of the seabed, the crown title is held by the federal government and not by the provincial governments. And so in those areas, the federal government can regulate and protect from, hopefully more protect from, but can manage important activities, things like mineral exploration, oil and gas, create protected areas. So there are a number of things that give the federal government real power because of the crown title. That being said, and so under those powers, I think some of the main laws that a lot of people will probably be familiar with, but are things like the Fisheries Act, which manages fishing, the Shipping Act, which manages aspects of shipping, and also the Ocean Act, which enables the federal government to create what are called marine protected areas. And the marine protected areas under the Ocean Act, because the federal government can manage all these activities, are some of the most comprehensively protected and managed areas in our ocean. That being said, I think a lot of folks will be surprised to know that the jurisdiction of the provincial government, so the powers of the provincial government in British Columbia, are actually quite significant with respect to ocean management. And the reason for that is that there are actually large areas where the Crown title is not asserted by the federal government, but is actually held by the provincial government. Alexis, do you mind skipping to the next slide? Thank you. Or the one before this. I think you got to go backwards a few now. Perfect, thank you. I'm going to talk about the areas where the province has Crown title. And so the first ones that are the most significant is just like on land, down to the shoreline, down to the low tide water mark. The province has Crown title in those areas. And in BC, where we have archipelagos and huge islands and bays and large coastlines, we have, I think it's about 30,000 kilometers of coastline. So that's an important area of the ocean where the province has significant powers to manage those areas. The other areas are these areas called internal waters. So internal waters in international law are kind of thought of as within the jaws of land. So we're thinking of things like bays and sounds and places like that. But the internal waters and the areas that are held by the BC government in BC are actually quite bigger than that. In the 1980s, there was a lot of interest in oil and gas exploration in the area between Vancouver Island and the mainland. And there wasn't clarity on which level of government had the Crown title in this area. And so it went to the Supreme Court of Canada, and it was determined that the area between Vancouver Island and the mainland, in that area, the Crown title is held by the provincial government and not by the federal government. So you can see all those areas in blue between Vancouver Island. Those areas, the Crown title is held by the provincial government. It wasn't the subject of that court case, but arguably the same analysis would apply between Haida Gwaii and the mainland. And so you can see those large areas that are kind of hatched in blue, where the BC government has quite significant abilities to regulate activities. And so, Alexis, if you don't mind going back to the slide right before this, I'll just show you. So in those areas where the province has the Crown title, you can see there's a number of activities that the province can regulate. So in those areas, things like mineral exploitation, oil and gas, but some of the more common things that you might think about are things like regulating where wharves and docks and marinas are, the sites of aquaculture, how aquatic plant harvesting happens in these areas. And I think perhaps most importantly, or for a lot of people on this webinar, the province is also able to create protected areas there. So things like provincial parks with marine components. The only downfall of those parks from provincial parks in the marine area is that it doesn't matter which Crown title you're on, so whether you're in provincial Crown title areas or federal, in either case, fishing and navigation remain federal responsibilities. So in order to protect those activities in provincial parks, you would need the cooperation of the federal government. And I think that will be a perfect segue to pass it to Stephanie, who's going to talk to you a bit about some of the efforts at cooperation that have happened.
Thanks, Michael. Alexis, if you could go to the one after this. Thank you. So I think it's pretty clear from everything Georgia and Michael have said that it's important for governments to work together to protect the ocean, given their unique and complementary powers and the different areas over which they have jurisdiction. So I'm going to take you to an example of intergovernmental cooperation from BC's North Coast. And it's happening in the area between northern Vancouver Island and up to the Alaska border, as you can see on this map. It's called the Northern Shelf Bioregion. I think Fisheries and Oceans Canada has named a bunch of different bioregions throughout Canada's ocean, and that's this one. And it's where Canada's first marine protected area network is being developed. And it's the first time that the provincial, federal, and Indigenous governments in that area have come together to work on protecting the ocean anywhere in Canada. And what's happened here is that it's been a long process, but we're now at the point where the 3 different governments have collaboratively identified a number of sites that should be protected. And the next step is to implement those sites. So the interesting and kind of complex legal questions arise as to which protected area designations are the best for the different sites. And it really depends, as you can probably tell from what Michael said, on where the sites are located. So if you have nearshore sites, it might be better to have a provincial park designated in that area and perhaps overlay some type of federal measure to stop fishing or shipping within the area. And if you're in the offshore and you really want to regulate fishing and shipping, then a federal tool might be the better option. And it's I think quite like exciting project though, that this is happening in that area, that all 3 governments are coming together, and something that really sets a standard for what can happen on the BC coast. And pretty excitingly, we're now starting to see Fisheries and Oceans Canada interested in implementing marine spatial planning. So zoning of the ocean and what activities can take place where, including what areas are protected, down here on the south coast. And I hope to see more of that going forward. And I'm going to pass it over to Deborah now, because I think the last piece that we really want to talk about is the important role that local governments play in protecting the coast and ocean within their jurisdiction.
Okay, thanks, Stephanie. Alexis, can we have the next slide? Thanks. Thank you. So yeah, so I guess the final part is, how do local governments, the little fish, fit into this multi-jurisdictional landscape? Next slide, please. So to answer that very briefly, I think it's useful to take a look at the source of local government authority. And a key thing to note is that local government authority is delegated authority from the province. So it's kind of like a sub-jurisdiction. And the province has used a legal instrument called letters patent, and there's an example of one on the left, this yellow document, to designate municipal and regional district boundaries and authorities pretty much across the province. And in the case of local governments along the coast, in many cases, the boundaries that are assigned to local governments extend seaward of the shoreline. And on the right-hand side of this slide, you can see the municipal boundary of Parksville and how it extends out into the marine waters. So that's the boundary, but the authority given to local governments to make rules and enforce them is more nuanced, and that's in the Local Government Act and the Community Charter for the most part. So could we have the next slide, please? Thanks. So for this, we need to consider another important boundary, and that's the natural boundary, or the high watermark. And this isn't a line that's made up and drawn on a map, although it can be represented on a map, but it's literally the high point where the sea goes out in a big, sea comes in a big storm. So the high watermark. And it's determined by a surveyor going out and actually walking along the beach and making a determination about where that line is. Now, below the natural boundary, the foreshore and nearshore area, so the shoreline and that nearshore area, is Crown provincial land. But of course, it's also subject to federal and Indigenous jurisdiction, as we've heard, but we're just gonna try and stay in this provincial local bubble for a minute. And so in this area between the natural boundary and the local government boundary, in marine waters, so that gap, the shoreline area, local government authority is quite limited. So I would say this is well understood by most local governments, although it can be a source of frustration. But I think it's fair to say that it's less well understood by others, including private property owners on the landward side of the natural boundary, who often assume they have property rights on the shoreline itself. And this lack of understanding leads to uncertainty and frustration and sometimes conflict. So given all this, what then can local governments do within their limited authority to protect coastal areas? The guide goes into a lot of detail about this, obviously, but I'm just going to mention two key tools. So one is through long-term planning. So local governments develop these plans for their communities called official community plans, and they provide broad directions about land use and infrastructure and protection for sensitive ecosystems. And there's usually a community engagement process that goes along with it. So it's an opportunity for a community to really think about its relationship to the shoreline. And through OCPs, local governments can put in place policies that shape the type and location of development and redevelopment along the shoreline. And so in that way, guide future decision-making and permitting. So it's a fairly powerful tool. One of the ways to implement official community plans is through zoning by designating permitted uses in different areas. So zoning usually does also require setbacks, restricting development to some distance back from the natural boundary. So that can also help because it creates a buffer that can help protect the shoreline. And there's an important nuance about the zoning power in particular, and that's that it can be applied out to the marine boundary, so beyond the natural boundary, out into the water, on the surface of the water. And the BC Court of Appeal has confirmed that local governments can zone an area within their boundaries, the marine boundaries, to prohibit long-term moorage, so that particular use. They can't interfere with navigation, which is federal, or short-term moorage, but they can restrict long-term moorage. So that's just an example of how local governments can use their powers. And next slide. And I wanted to give an example of how this is kind of playing out in practice and some of the solutions that are being developed at the local level. This is an example of, or it's a picture of a schematic of Mannion Bay along Bowen Island. And it's interesting because I think it illustrates both the limitations and the authority of local governments in a practical way to address some of the challenges. So Mannion Bay historically has been a place with Indigenous activity and use, and more recently in colonial times, it's also been a recreational area. But it had become overrun with beached and derelict vessels and pollution on the foreshore and in the water. And I guess you could say that the social drivers of all of this are somewhat complex, but the short story is that Bowen Island was interested in finding a way to restore more healthy relations in Mannion Bay. So they developed a strategy, and to support its implementation, they obtained a 30-year license of occupation from the province over the foreshore and nearshore area. And through this license of occupation, they obtained more authority than they would ordinarily have as a local government. And in particular, they obtained authority to regulate moorage in a more refined way. So now they can regulate the number and location of moorages and charge annual fees. And they've also worked with a very knowledgeable and helpful Sea Change NGO to identify sensitive eelgrass areas and figure out where to locate moorages so to avoid more damage to those areas. So that's a really high level description, but it gives you an idea of how people are working at the local level to find solutions to what is fairly siloed jurisdiction along our coast. And it's just another example of the collaboration that's happening and the great work that can be done going forward. Thank you. I'll pass it back to Stephanie or Alexis.
That's our brief run through of ocean jurisdiction. We wanted to say thank you to all of you for joining us. We're looking forward to answering your questions in just a minute. But as Linda said, we also want to say thank you to all of the collaborators and funders who supported our work, especially a big thanks to Sitka Foundation and the Gordon and Betty Moore Foundation, without whom this wouldn't have been possible. So yeah, thank you, and thanks to my fellow presenters. And I think we'll open up the floor to questions, and Alexis is gonna moderate that.
Yeah, thanks everyone for your great presentations. So I think how we're going to do this, we have a limited time today for questions. So we received a lot of questions in advance of the webinar. And if you look in the Q&A window, you should see a bunch of questions in there from WCE Law. So those are based on a lot of the questions that we received in advance of the webinar. So feel free to go in there and use the like button to upvote the questions that you're most interested in, and we'll kind of start from there. So the first question that we have here is, what is the current law and policy related to work in the foreshore that is part of nature-based measures to protect coastlines and coastal properties from erosion and sea level rise?
Okay, I can answer that one. And then it is somewhat related to the question that follows about hardening shorelines and how that. Oh, are we voting on that or am I answering that? Sorry.
Answering.
Okay, sorry. So this is actually something that West Coast has been working on with the Green Shores program at the Stewardship Center of BC for some time. And I think DG Blair from Green Shores is actually might be on this webinar. But one of the difficulties that I could say, like based on the conversation about the natural boundary, is that at the present it's easier for a coastal property owner from a permitting perspective to just build a wall along the boundary of their property than it is to undertake more nature-based approaches, which would involve softening the shoreline and would mean that they needed to essentially get onto the foreshore and have some restoration activity on the foreshore, because then they have to go through provincial permitting, they have to get approval from DFO potentially. It could also be affected by Heritage Conservation Act, and they would need an alteration permit. It's also, as Georgia said, everywhere the territory of Indigenous nations. So there's a lot of factors to consider to undertake that approach. So one of the issues is that even though that is provincial crown land, as Michael mentioned, the province doesn't have a coastal strategy or a standard way of dealing with these types of applications. So there isn't even a specific policy that you can follow. So as I mentioned, we've been working with Green Shores on this to support them because they have a standard for doing these types of projects, and working in conversations with folks at the province to try and develop a policy so that this type of work can go ahead in a more efficient way. The bottom line is that we know that hard armoring is really bad for the coastal environment. It's really bad for the forage fish, as I think was mentioned in the question. And also these problems are going to get worse with sea level rise as we have more storms and more coastal erosion happening. So I think this is an area where we could really call on the province to show some leadership in this regard.
Alexis, I might take that opportunity because I think this is relevant to a number of questions. I might just take this opportunity to tell you about some exciting developments. One thing that has often been a real concern with respect to provincial jurisdiction, we talked about how there actually is quite significant provincial jurisdiction in BC. That being said, BC administers its jurisdiction or manages decisions on coastal issues through a number of different ministries under acts that aren't really, they weren't created specifically to address ocean management. So a lot of decisions are made under the Land Act. And a lot of decisions are made under different ministries, like the Ministry of Agriculture, the Ministry of Forest, the Ministry of the Environment, and they're not always made with an overarching goal or strategy for how this is going to impact the coast, how we're going to manage cumulative impacts. And shorelines are one area where there's really a lack of a strategy from the province. Some things that other people have asked questions about are things like mooring, where there also isn't much involvement from the province. And West Coast, Linda will be very much aware of this because Linda's been calling for this for years and years and years. But we've been working on an initiative to get the province to commit to creating a coastal strategy and a law so that it has a more integrated management of the coast. And there's a link to our website for that initiative in the chat. And I just wanted to say the good news on this front is that we finally got commitments from the new government that just announced its cabinet, and in 5 of the mandate letters to the different ministers that have just been appointed, they've been mandated to develop a coastal strategy for BC. So that's a really exciting development. It's also, I think, somewhat indicative that the mandate to develop a coastal strategy found its way into 5 different ministries' mandate letters. I'm not sure if that's a record. I'd like to think it is. But that kind of shows you how dispersed coastal management is within the provincial government, and kind of points to the need for some better coordinated governance on that front.
Thanks, Michael. So now I think let's go to another question from the Q&A in here, since we've had a couple already on shorelines. Where are the opportunities for First Nations to tangibly assert their law and jurisdiction in this jurisdictional web?
Wow, that is a great big question. I can take a first crack and anyone can jump in afterwards. I mean, I think Indigenous nations up and down the coast are acting and asserting their laws in so many ways right now. I think some of the broad categories that I use in my colonial brain to think about them, those initiatives run from Indigenous Guardians programs, which you're increasingly seeing up and down the coast as eyes and ears on the ground and waters to ensure that territories are cared for. And increasingly, those Guardians programs are calling to have enforcement powers, essentially, to enforce their laws within the territories. That's one bucket, Guardians programs. Another bucket I already mentioned is Indigenous protected and conserved areas, which many nations along the coast are working towards within their coastal and marine waters. Another kind of broad category are nations that are coming up with or writing out laws that address specific issues. So one example, again, from the Kitasoo Nation is a herring management plan that's based on their law. I'm talking a lot about herring, but I just happen to know a little bit more about that work. And other stewardship laws. The Heiltsuk Nation, as Linda mentioned, is in the process of developing Respecting and Caring for, or Taking Care of Our Ocean Relatives Act. And I mean, the list goes on and on. Those are a few examples. Again, MPAT is another great example of Indigenous nations bringing their laws and governance systems to the table with provincial and federal representatives. Really, the list is endless, and I'm happy to answer more about that, but that's my first crack.
Thanks, Georgia. So I think we've got time for at least one more, probably. There's a question here that has come up a lot of times for us in the past as well. The BC government promised to address the freighter anchorage issue, the increased number of large freighters anchored offshore, causing noise disturbances and pollution. So what are the legal tools that they can use?
Okay, it was interesting to hear you say, what can the province do on this front? Because unfortunately, as we've been talking about a lot, shipping and navigation are a federal responsibility. And so there are certainly things that the province can do, but ultimately, if we really want to address this issue, the government that should be changing and should be addressing this issue is the federal government. I just want to say, maybe this, I don't want to complicate things too much at this point, but one thing that Deborah did mention, which is very much related to this issue of anchorages, is that the courts have found that the right of navigation, which is kind of a common law, kind of like an international right to navigation, but is also what the government, the federal government is in charge of regulating. That right also includes a right to be able to temporarily moor your boat. It's kind of seen as a basic part of navigating, is you need to be able to moor and anchor your boats when need be. That being said, the courts have recognized that anchoring for longer periods of time starts to no longer be part of the public right of navigation, and is actually just, you storing your boat somewhere. And so there have been a lot of municipalities, like Deborah has mentioned, who have been frustrated with kind of boats and moorages kind of anchoring everywhere in an unregulated way, and oftentimes it leading to problems with derelict boats and just pollution and other things. And so municipalities have started, such as Bowen Island, Victoria's another municipality that started to set up bylaws where they do regulate in certain areas anchorages and moorages. So for example, in the Gorge in Victoria, there's now a bylaw that says, anyways, it regulates moorages that last longer than 48 hours. And so there are areas where municipal and provincial governments can get involved in this, but ultimately, if they regulate temporary anchorages and moorages, that would likely be found to be unconstitutional, because it's really a federal government responsibility. But the province can put a lot of pressure. It can negotiate with the Canadian government. It can even do general regulations about some aspects of where anchorages might happen and that kind of thing. But ultimately, it's the federal government that should address this.
Thanks, Michael. Okay, there's a couple other questions here. One is, what area of the ocean within the jurisdiction of Canada or BC is the hardest to protect effectively through law?
Yeah, I'll go for this one, and I'd love to hear what anyone else has to say on it too. But I think there's two answers to the question. The first has to do with what I mentioned about maritime zones in the presentation, that the federal government especially has the most jurisdiction up to 12 nautical miles offshore, and then slightly less jurisdiction between 12 and 200 nautical miles offshore. So within the exclusive economic zone, there's sometimes difficulties in protecting areas, especially from activities like shipping. But I think the real answer is the hardest part of the ocean to protect is the parts that are most used and where there's the most overlapping jurisdiction. So places like, I guess, English Bay would be a good example. Howe Sound is another good example, where there's a number of different governments with responsibility that need to coordinate in order to protect the area, and where there's also quite a lot of activity and ocean uses going on within the area. And so, but not to say that those areas can't be protected, they definitely can. And there's some great examples in the guide, especially the interjurisdictional chapter, that talk about different planning tools and protection mechanisms in order to address those areas, but they definitely take a bit more time and a bit more diplomacy to get there.
Thank you, Stephanie. There was one more quick question I think that we probably have time for, about which of these laws that are in the guide are useful also for people on the East Coast?
Yeah, I want to say this, I answer this one because we're very excited that people from the East Coast might also find this useful. And there's a lot in the guide that addresses laws, federal laws or international laws, and also Indigenous law that I think people from the East Coast would find quite helpful. All of the examples are from BC, but many of those laws have a national aspect or international aspect. And there's also a chapter on jurisdiction that could be helpful for people from other parts of the country. And I'll say the interjurisdictional chapter too has some great examples of what's been done in BC that could inform work on other coasts. Any other thoughts?
Sorry for that. Okay, I think we might have time for one more. Oh, I just see one question that I can answer really quickly. Is there an equivalent of West Coast environmental law on the East Coast? There is an East Coast environmental law as well, so you can Google them.
Yeah, and Lisa Mitchell from East Coast Environmental Law is on the webinar, and you can just, yeah, Google Lisa Mitchell. She's a wonderful advocate.
Great. Okay. Well, I think we might just have to cut it off there because we're getting really close to our 2 p.m. cutoff. But I just wanted to say that, you know, obviously we couldn't get to all the questions because we had so many. But the answers to many of these questions are actually in the guide. So I would encourage everyone to take a look and dive into the areas that you are most interested in. We will also be following up tomorrow with an email with some helpful links, including the link to the guide and the link to the recording of this webinar, which will be on our YouTube channel. We'll also include a feedback survey in that email where you can give us feedback on what you liked, what you didn't like about today's webinar, and any ideas if you have for future webinars and resources that you'd like us to tackle. So I just want to also say a huge thank you to everyone who tuned in today, and for our panelists, our experts, the authors, our funders and donors and supporters. Thanks again to the Moore Foundation and the Sitka Foundation who were vital in supporting the creation of this guide. Please go check out the guide on our website, share it with your friends and colleagues. We've left a link in the chat as well. And another note is that we have a quarterly marine law newsletter, which is actually going to be going out later today. So if you aren't already signed up, it's called The Law Aquatic, and you can find it on our website. And it's got, you know, lots of great updates on new developments in ocean laws. So I think that's about it. You can find more information, including ways to support our work and donate on the website at wcel.org. And yeah, with that, anyone else want to say final words?
Thank you.
If I can just say one final thing, I thanked our supporters again. This is such an amazing accomplishment, 3 years of hard work. And I did want to single out Stephanie, who is the lead author and who really brought it over the finish line, as I said, but corralled us, kept going. And we have some exciting, she has some exciting developments in the work to get this to an even broader audience at a later date, potentially through publication with an academic press, which is very exciting, but don't want to jump the gun on that one. But thank you, Stephanie, for leading us to this day and making sure that the beautiful looking guide is out there in the public realm. I know it will be useful to everyone, and it's just great to see it. So thanks so much.
Thanks, Linda. And it was definitely a team effort. So thanks to all my collaborators and co-writers and to everyone for tuning in today. We're so happy that you joined us.
All right. Thanks, everyone. Take care.